Okay, here's, we have clause number 24 CR 565, the state of Texas versus Jonathan Cruz.
Yes, sir.
And your attorney is Mr. LeBlanc, and the state's attorney is here. You're charged with this state jail felony,
June 16th.
and it is included with the indictment or allegations of two prior convictions in unlawful delivery of a controlled substance in 05 and attempted assault, family violence in 2012. Those are state jail felonies. If you were convicted of this state jail felony and these two state jail felony prior convictions in paragraphs 2 and 3 were proven true, you were looking at a state jail felony punished as though it were a third degree felony. Correct, everybody?
That's correct.
So you're looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand all of that?
Yes. Yes, sir.
All right. Everybody has some time to think. Where are we headed?
Judge, we came here yesterday. We had a plea. Or she's offered state jail time, so she's got enough time to come. This case, I was advising him that.
For a state jail.
Yes,
That's what,
He could still go to
but
trial.
it could be
Yes, Judge.
punished up to 10 years in prison if he doesn't take the deal.
Correct.
That's correct, Judge.
And
What's he gonna
here
do?
he's offered a time served. She's offered a lesser included the first count for state jail,
How much time does he have credited?
800 something.
Maybe 842 days now.
What's 2 years worth? What's 2 years? 730.
Yeah, yes. And Judge, I've only, I had this year's month first. And so, but we're ready for trial. It's just that.
How many days does he have?
I'm triple checking that.
At the end of the day, it's his free will. It's his choice, you know. He gets to decide what direction it goes in. I mean, they're just go with it's his life.
842 days. So if he has credit for time served, if it's a state jail, we can release him from the county jail today.
It's got over 100 days more.
Uh,
So what are we doing? We're gonna go to trial?
No, Judge, well, yes, I guess so. We had a plea set up and he wanted to talk to the court because he's done his own research and and he thinks that he should be sued civilly before criminal because it's a theft of.
No, that's not a debate you and I are gonna have.
Just say it's right.
Just not a debate you and I are gonna have. I am presiding over a criminal charge that has been handed up by the grand jury. This isn't going to go into a debate between you and me as though it should be civil or not. The prosecutor takes care of what prosecution direction it goes in. He defends you, and I am the arbitrator of the charging instrument. So I'm not going to debate. I'm not going to talk about whether it should be civil. This is a criminal court, and it's been handed up by the grand jury. Not her. They asked for it, but the grand jury makes the choice. And then I respond by two things, either disposing of it by allowing the parties to agree to a disposition, or like yesterday, we had another 615th jury trial here, 615. And they disposed, the jury found guilty and sentenced. And that's what happens. We try cases, but it's this thing with a civil is not a debate with me. But as long as you are aware, they've offered you a plan of disposition where you can walk out today. And well, that all I'm talking about is what is in this set of facts in this case. Now, if you don't want that, then what happens is it will defer, you'll set it on the trial docket and you'll be looking at up to 10 years in prison. And that's your choice, though. Everybody up here makes a choice.
I was released from prison, I was the victim involved in it. This one.
All right. We're just going to put it on the trial docket. It's not I told you it's not a debate. It's your choice, sir.
You said.
You're not debating with me.
Debate, I'm speaking.
I'm making a ruling, sir.
Said that he's important, that he got my hat, that I'm.
Once again, that has nothing to do with what the decisions I make, sir.
Hey, this man, I'm not looking for free representation.
Okay, then here's what you do. Go to trial.
It says.
We'll set it for trial,
It says
sir.
right here, before I.
That is all.
It said, before I go, before criminal court, it's a civil court matter. It says right here, you won't let me read the law.
It says on the, it says on the.
You go have my list of documents?
Yes, sir.
Did you send all that stuff to your lawyer?
Yes.
Okay,
It's
that's
the
him.
reason- it's
All
the
right.
reason for me to-
He's handling it.
To you.
He's gonna handle it.
That I haven't done.
We're gonna set it for trial. It'll be set for trial. Get ready for trial. And we'll let a jury decide
But then he'll move right
what
at the car.
direction it should head in.
I didn't even, he brought that up.
All right.
No, he's here for.
Oh, okay.
Some defendants really work real hard against themselves, but that's one of those cases that that's the third or fourth time we've talked about the same subject matter, and he doesn't seem to want to listen, but he has a right under the Constitution for a jury trial. That's what we'll do. Okay, Joseph Babineau.